Ever wonder what happens when a massive company in India starts to go under? Well, there's this incredibly powerful law that steps in to play both doctor and judge. It's called the Insolvency and Bankruptcy Code. And trust me, this isn't just some dusty legal document. It's a high-stakes rescue mission that affects the entire economy.
So let's just imagine this for a second. A huge company, one you definitely know, is about to collapse. It owes money to pretty much everyone: banks, its suppliers, even its own employees. What on earth happens next? Who gets their money back? Who ends up losing everything? And maybe the biggest question of all, who gets to make those life or death decisions for the company?
Before 2016, the answer was, well, it was a complete mess, a legal black hole. Companies would get tangled up in this crazy web of different laws, sometimes for decades. By the time a case was finally sorted out, the company was basically just a skeleton, picked clean by years of legal fees. There was literally nothing left to save.
So, to fix this disaster, India introduced a real game changer: the Insolvency and Bankruptcy Code, or the IBC, back in 2016. And this wasn't just another law. No, this was a total overhaul designed from the ground up to be fast, to be efficient, and to focus on one main goal: rescue. All right, so here's our game plan for this explainer. First, we're going to dig into what gives the IBC its incredible power. Then, we'll meet the main players in this corporate drama. After that, we dive right into the heart of our story, the huge fight homebuyers had to put up to get justice. Then we'll look at the two big outcomes: rescue or shutdown. And finally, we'll see why this is a law that is constantly changing.
So, what is the secret sauce behind the IBC's power? It's not just about the rules themselves, but the very kind of law it is. And it all starts with its name.
Okay, this is a really important distinction. See, an act is just one law among many, but a code is the boss. It's the king of the castle. The IBC was built to be the supreme authority. A specific part of it, Section 238, basically gives it the power to say, "I'm in charge here," and override any other law that gets in its way. When a company is in trouble, the IBC has the final say, period. And that one simple fact has completely changed the game for investors and business culture in India.
Okay, so we know the IBC is powerful. We get it. But who are the main characters in this corporate soap opera, and what's the one critical rule that kicks the whole thing off?
The whole process is really driven by the creditors, and they're basically split into two big groups. First up, you've got your financial creditors. Just think banks. Their relationship is pretty simple. They loaned money, and they want it back, plus interest. Then you've got your operational creditors. Now, these are the folks who actually keep the business running. Employees who are owed a salary, or the suppliers who delivered the goods. They're owed money for real services. As soon as the insolvency process starts, the court does something called declaring a moratorium. The source material has this beautiful description for it, calling it a Sanjivani Bhuti, which is this mythical, life-saving herb from Indian epics. And honestly, that's the perfect way to think about it. It's like a legal force field. All the lawsuits, all the recovery attempts, every claim against the company, they're all frozen. This gives the company some desperately needed breathing room to try and figure out a rescue plan without being torn apart from every direction.
But here's where our story hits a major snag. What happens when you have a huge group of people who don't really fit into either of those neat little creditor boxes? Well, this was the massive dilemma facing thousands upon thousands of homebuyers in India.
And here is the absolute core of the problem. When a big real estate developer went bankrupt, all the people who bought homes from them were just stuck, left in a legal no man's land. We're talking about people who poured their entire life savings into a dream home, but they weren't financial creditors because they didn't technically give a loan, and they weren't operational creditors either because they didn't supply a service. So they had zero official status, which meant they had no say in what happened to their own money.
This huge injustice, as you can imagine, sparked a major fight. This is the story of how a group of people with no power fought their way to the decision-making table and, in the process, actually changed the law itself.
Now, this journey was not easy. At first, the courts just kept confirming it. Nope, homebuyers don't fit the legal definitions. But then, some really big cases started to make their way up to the Supreme Court, and the court recognized their disadvantageous position. Basically, their money was trapped, and the IBC's own rules meant they couldn't sue or do anything else about it. The pressure just kept building and building until June 2018, when Parliament was finally forced to act.
So this right here was the legal wall they kept hitting. The original definition of financial debt was all about phrases like time value of money and commercial effect of a borrowing. In the real world, everyone just interpreted that to mean a classic bank loan. It just didn't work for the situation of a home buyer who paid in advance for an apartment that wasn't even built yet. And boom, here is the fix. They just added a single explanation. And notice that key word in there, deemed. The law now says that any money raised from a home buyer shall be deemed to have the effect of a borrowing. I mean, it's a brilliant legal move. With that one little word, thousands of home buyers were instantly reclassified as financial creditors, and they finally got a powerful voice in deciding the fate of the company and their money.
Okay, so now that the home buyers and all the other creditors have their rightful seat at the table, what do they actually do? Well, their main job is to choose between two very different paths: rescue the company or shut it down.
One thing you have to know about the IBC is that it is obsessed with speed. The rescue process, which has this fancy name, the Corporate Insolvency Resolution Process, or CIRP, is on a very strict clock. The whole thing has to be done in 180 days. You might get one 90-day extension, but that's it. There's a hard deadline of 330 days, and that even includes any time spent in court. If a rescue plan isn't approved by then, the company's fate is sealed. It's off to liquidation.
But wait a minute. Liquidation under the IBC isn't always the corporate death sentence you might think it is. What's really fascinating is this idea of life after death. As you can see from this court ruling, the goal can be a beneficial liquidation. What that means is the person in charge can actually sell the entire company as a going concern. They try to find a buyer who will just keep running the business, which preserves its value and, most importantly, saves jobs.
Now, if the company does have to be sold off piece by piece, there's a very strict order for who gets paid. The best way to think of it is a waterfall of cash. The IBC completely changed the lineup. Just look at the difference. Workman's pay for 2 years is now right at the top, on the same level as the big banks, and unsecured lenders now get paid before the government does. The big idea here is that this creates a predictable, fair system, which is absolutely vital for making people feel confident about lending money in the first place.
And this brings us to our final, and maybe the most important point of all. The Insolvency and Bankruptcy Code isn't some old rulebook that's carved in stone. It's a living, breathing piece of legislation that's always changing.
I mean, this timeline right here tells the whole story. Ever since it was created in 2016, the IBC has been constantly evolving. It adopted in 2017 to stop shady promoters from buying back their own companies. It adapted in 2018, as we saw, to help homebuyers. It adapted again in 2019 to give everyone a little more time. Every single one of these changes is a direct reaction to a real-world problem, which just proves this law is always being fine-tuned to help the economy.
So, what's the big takeaway from all of this? The IBC isn't just another bankruptcy law. It's a really powerful economic tool. Its number one mission is rescue. Its main method is resolution. And its greatest strength is its ability to adapt and change.
And that really leaves us with one final thought to chew on. The story of the home buyers proves that laws have to change to protect people who are vulnerable. So, as our economies face brand new crises down the road, things we can't even imagine yet, how must these rules for corporate rescue keep evolving to find that tricky but absolutely essential balance between the rights of everyone involved?